Good morning.
Your Honor, before we get going, you'll recall the trial of the co-defendant in this case, where we got through certain testimony, and with testimony, we decided to extend an offer to.
What was the name of the co-defendant?
Got it right here, Judge.
Even with the name, you're asking a lot of me, Mr. Coleman, but without a name, you're really asking a lot.
With Jose Lopez Palmias, it was a case where we employed the
Yes.
sorry,
The translators from Houston and
yeah.
Okay. And so something has been worked out based on that in Mr. Rodriguez's case? Okay.
The Kenny Rogers area of prosecution is what I was thinking, but that's the one.
Yes. No one wins.
Exactly.
I thought it was Rivers Echoes, Virgin Islands, was that what the Dolly Martin?
Mr. Turk, will your client waive the formal reading of the indictment?
Yes, ma'am.
While she does her deal.
I don't think it's true.
No, I'm talking about what in the whole.
I do damn right. Just walk away from you.
Give me that. All right, Mr. Rodriguez, in cause number 23, DCCR 1415, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from June 18th of 2023. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Alright, we're jumping straight into a courtroom where things are already in motion, and trust me, when a judge references a co-defendant trial, it usually means there's a bigger story behind the scenes. Deals may have already been made and someone might be getting the short end of the stick. Stay sharp.
Yes.
And because you did what they charged you with.
Defend myself.
Is anyone forcing you to plead guilty?
¿Alguien me está forzando a declararse culpable? No.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with your attorney, with the interpreter?
Yes.
Do you fully understand them?
Sí, los entiende. Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
I understand.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
I understand.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Rodriguez is not competent?
No objection.
All right, sir, I'm going to find.
This right here is huge. When the court says something has been worked out, that's usually code for a plea deal. Translation: instead of risking a long trial, the defendant may accept a guaranteed sentence. But hey, race, the real question, was it a smart move or pressure behind the scenes?
That you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon. Sentence you, in accordance with that agreement, to a term of 2 years in prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. And
Waiving the reading of the indictment might sound minor, but it's actually a strategic move. It speeds things up and signals the defense is cooperating. But think about this: if you were facing serious charges, would you rush the process or slow everything down to fight every detail?
You're a dismissal for the Shane's case, Judge.
right, you're currently serving time in TDC, is that correct?
Yes.
This will run concurrently or at the same time with whatever you're serving time with as well.
la prisión.
And I will sign a dismissal as part of this agreement. And cause number 23, DCCR 1416. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. That admonishment is in Spanish. You need to read it carefully. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Turk. Right, good luck to you, sir. Thank you, Mr. Turk. Thank you, Ms. Bursch.
Thank you, Judge.
Miles? Okay, so this is 24 DCCR 233.
And there it is, the word that changes everything. Guilty, no trial, no fight, just a direct admission. But don't be fooled, this doesn't always mean defeat. Sometimes pleading guilty is actually the calculated move to avoid something much worse.
0, just trying to get up to speed. Good morning, ma'am. And Ms. Miles was in court and entered pleas of truth to counts 1 through 4 in a motion to revoke unadjudicated probation. On probation for tampering or fabricating with physical evidence, a third-degree felony, and I reset the case.
She pled true to counts 1 through 4, not
Right.
true to count 5.
Not true to count 5, which is the count with regard to that she was. So all of these have to do with, most of them have to do with the ISF and the fact that she didn't successfully complete it and was removed from it. And count 5 specifically made the allegation that she was walking around in the quote living room of the dormitory during count time, which was against the rules. We reset it, and I asked for and received the a report, the discharge report from ISF. And so I guess where are we now?
So one of my main concerns is, and I'm not, well, obviously she's just started probation, but there is a history of mental health issues. I don't know if necessarily if Ms. Miles has been on the mental health caseload. There have been several diagnoses that she has. I'm not sure if proper medication may be an issue. I know she recently told me that they have put her back on some type of medication, which I do think has contributed to some of the behaviors. Due to her not being on probation very long and not being at ISF very long, we are asking that she be given another chance to try to make this right to successfully complete the probation. Mainly that was the issue on the motion, was her not completing ISF and adhering to all of the rules and regulations there. So I don't want the court to totally give up on her at this point, but we understand obviously that a person needs to successfully complete ISF when they...
Now this is where it gets interesting. He says he acted in self-defense but still pleads guilty. That's a contradiction on the surface. So what's really going on here? Did he feel he couldn't prove it in court, or was the deal just too good to risk losing?
They were ordered.
I mean, what option? And just for the record, if you'll raise your right hand, please, ma'am, do you swear or affirm the testimony you're given this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And so what options and what's probation's thought with regard to any type of mental health issues that could be addressed?
Well, prior to her placement at the facility, I did go to the county's correction facility and speak with Miss Miles. And I told her that upon her completion of the ISF program, that I would have her meet with and Spindletop to have all of those assessments that she would need to see if that she could be accepted onto the mental health initiative caseload. But we didn't make it that far.
I guess the problem is if there are those issues, then those need to be addressed in order for her to be successful wherever, including ISF. So and those evaluations cannot be done while she's in custody at our jail, correct?
I don't know what can be done at the correctional facility, but I do know that I spoke to some members from Tacoma to have it set up to where they could start that process while she was at the facility, at the ISF facility. But due to her, disruptive behavior there, it didn't get very far.
So if we need an evaluation done because the disruptive behavior could potentially be because of mental health issues, then what are my options?
I believe that the staff from Spindletop can go out to the facility and do some type of assessment.
I know we've had difficulty getting them to do that.
That's what my understanding.
2 years, that's the final number and likely much lower than what he risked at trial, but the hidden cost, no appeal, possible immigration consequences, and a permanent felony record. The court moves fast, but the impact of this moment will follow him for life. No, watch closely because the next case shifts from punishment to something even more complex: mental health and second chances.